This case wastes absolutely no time diving into chaos, and trust me, it only gets worse from here. What you're about to witness is a courtroom moment where accountability hits hard, and not where you might expect. We have a defendant, Mr. Jones, sitting behind bars for over a month, and somehow no one has been actively working his case. No discovery reviewed. No meaningful attorney-client communication. That alone should raise serious red flags. But here's where things take a dramatic turn. The attorney who did appear is now trying to withdraw, and his explanation? It doesn't quite line up. What starts as a routine procedural motion quickly spirals into a full-blown judicial interrogation. The judge isn't just listening, he's dissecting every word, every inconsistency, and every lapse in professional responsibility. Yes, and let's be clear. In criminal law, time is everything. Delays like this can impact evidence, strategy, and even a defendant's rights. So the big question becomes, how did it get this bad? Was this just miscommunication, or something far more serious? Stick around, because what unfolds next is a powerful reminder of what happens when the justice system holds its own accountable. And trust me, you're going to want to hear what the judge says next.
He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. You all right?
Floor's uneven right now.
Court calls the case of people versus Corey Jones. Basis.
Good afternoon, Your Honor. Edward Lucas on behalf of Corey Jones in 1318.
Good afternoon, Judge James Murray, P 5490, appearing on behalf of Mr. Jones on the subsequent matter.
All right, what are we doing?
Now, today,
Your motion.
great. This is the eighth time for my motion to withdraw. First of all, I want to apologize for inconvenience the court. If so, I have talked to mom. Well, actually, I was in contact with Mr. Jones's mother for the matter that brother counsel is on now. They were saying me on such matter. In the middle of negotiations for such case, he was arraigned on this new matter. In the rush and the haste of attempting to get off that case to make sure arraignment went successful, failed to put limited on my appearance for the arraignment purposes. And after discussions with mom, she had decided to go in a different direction. So with that being said,
right here is where things start to unravel, and fast. The judge zeroes in on a critical issue. The attorney's written motion claims there was a breakdown in communication with Mr. Jones, but verbally, he's now saying he never actually spoke to his client at all. That's not just a minor inconsistency, that's a fundamental contradiction. In legal practice, especially in criminal defense, your filings must reflect the truth with absolute clarity. Courts rely on these motions to make decisions that affect someone's liberty. So when the written record doesn't match reality, it raises serious concerns about credibility and professional conduct. And let's not overlook the deeper issue here. The attorney was communicating through the defendant's mother instead of directly with the client. That's a risky move. Legally, one of the attorney's duties is to the client, not the family. This creates a disconnect that can lead to exactly what we're seeing now: confusion, delay, and frustration in the courtroom. So let me ask you, should indirect communication like this ever be acceptable in a criminal case? Or is this already crossing a line?
So with that being said, I will ask that my motion.
No, but your motion says that the relationship between you and Mr. Jones broke down.
Correct.
Okay, but that's not what you just told me.
So to flesh it out more, I was speaking to Mr. Jones on behalf through his mother. His mother was the one who went through everything. His mother reached out to me. His mother kind of did all the contacts. Mr. Jones has been incarcerated in Washington so far.
I know, but I'm trying to figure out what's the basis of your motion to withdraw.
The basis of the motion is that I was engaged by Mr. Jones's mother prior to the arraignment. Was never what I actually. She does not want to proceed with me as counsel.
Why didn't you say that in the motion? I guess because all this has done is delay Mr. Jones's matter. I just
Understood, Your Honor. I do apologize for the inconvenience.
well, it's not just apologizing to me, it's Mr. Jones. I mean, I'm trying to he's got a right to have his matter proceed forth, and now Mr. Jones, what do you want me to do? You know? My lord. Yeah. Grab that motion. Yes, Senator.
Yes.
Mr. Jurgensen, your matter, what are you doing?
Your Honor, I sort of the tail, the other case is sort of controlling. I'd be asking for an adjournment to follow that case. My case is a fleeing matter. The other matter,
I'm sorry.
is that just a fleeing case?
Yeah, but you don't have to take the baby out. That's what you're trying to do. I like hearing babies more than I do attorney. You're all right. Okay. Thank you though for having that consideration. You're good.
And I believe it's a 15-year max on one of the felonies in the other matter. So I think that I don't have that report. I don't know much about it at this time.
Has the discovery been settled? I mean, where is his case at this point?
I have not received discovery on this matter.
Pardon?
I have not received discovery on this matter.
While in our office, I do have the discovery in our file media. But I'm not sure.
He was arraigned on March 2nd. And so nobody's been working on his case since?
The arraignment for, let me just clarify, for the case ending in.
This
The
moment
one
right
you-
here is one of the most important, and frankly, one of the most alarming. The judge highlights that an entire month has passed since arraignment, and absolutely nothing has been done. No discovery picked up, no case preparation, no progress. For those unfamiliar, discovery is the backbone of any criminal defense. It's where the defense reviews evidence, police reports, witness statements, forensic data, everything needed to build a case. Without it, the defense is essentially operating blind. So when the judge says that's not how law is practiced, he's not exaggerating. This is a direct call out of professional negligence. And notice the tone shift. It's no longer just procedural. It's personal. The court is now stepping in to protect the defendant's rights because his own representation failed to do so. Well, as this raises a bigger issue, how often does this happen behind the scenes without being called out? And more importantly, how many defendants are affected by delays like this without even realizing it?
The one you entered an appearance on. He was arraigned on March 2nd. I'm now sitting here a month later and no discovery's been picked up. Nobody's working on his case. Counsel, that's not how law is practiced. Ever. And certainly not here in Washtenaw County. If you were going to withdraw, then you go ahead and you get the evidence. At least then when new counsel steps in, you can turn it over to them. But you don't do this way, and you don't do this to Mr. Jones. Have you ever talked to Mr. Jones?
Not directly.
Then why did you lie in your motion?
When I spoke to his mother, she indicated she represents.
Do you have a copy of your motion? Look at paragraph 2.
Okay, I'm here.
Read it out loud. What does it say?
It states that there's been a breakdown of communication between Attorney James Murray and Jones.
How is there going to be a breakdown if you never talked to him?
Your Honor, from my perspective, I was speaking to his mother. Expressed Mr. Jones's wishes. I should have outlined that in my motion after discussing that.
Meaning you should have told the truth and had full candor to the court, is what you should have had.
And here it is, the breaking point. The judge doesn't just question the attorney anymore, he outright accuses him of misleading the court. That's a serious allegation, and in the legal world, it carries heavy consequences. The key issue? Candor to the court. This is a fundamental ethical obligation. Attorneys are required to be truthful, transparent, and accurate in everything they present, especially in written motions. When the judge says, "You did mislead the court," he's essentially saying this wasn't just a mistake, it was a violation of trust. What makes this even more intense is how the judge reconstructs the narrative. He explains how the motion appeared to describe a direct conflict between attorney and client, but in reality, there was no relationship to begin with. Thus, that's not just misleading, it's potentially damaging to the defendant's case. And then comes the harshest line yet, questioning whether the attorney should even be practicing criminal defense at all. So now the question shifts. Was this incompetence or something more serious? And what consequences, if any,
What
should
you
follow?
should have had.
I'm explaining exactly what happened right now on the record. I was never attempting to mislead the court. I was speaking to.
No, you did mislead the court. You are making me, when I look at this motion, it appears that what has gone on is you and Mr. Jones are having communication, and for whatever reason, there becomes this irreconcilable thing between the two of you where you can't represent him. That's not it.
If I put a
You
minute,
never talked to him. And now he's a month out from the time that he's arraigned, and you never talked to him. You shouldn't practice criminal defense anywhere. Because your primary obligation is to your client, not his family, to him. Mr. Jones, what do you want me to do? It's your case, it's your life. What do you want me to do?
What do you mean? Like, as far as what?
An attorney. I know you got Mr. Drukas on that one, but do you want him representing you?
This is a rare
you-
and powerful moment in any courtroom. The judge doesn't just grant the motion, he delivers a public and unmistakable rebuke. When he says, "I'm going to grant the motion because he hasn't done a darn thing for you," that's not just justification, it's condemnation. Judges typically maintain a level of restraint, especially when addressing attorneys. But here, that restraint is gone. The message is clear. Failing to act in your client's best interest is unacceptable, period. And telling the attorney not to come back until he's ready to practice properly, that's a direct hit to professional credibility. What stands out even more is how the judge shifts focus back to Mr. Jones. Despite everything that's gone wrong, the court is actively trying to reset the situation and ensure he gets proper representation moving forward. But let's pause for a second. How would you feel if your legal fate depended on someone who never even spoke to you? Is this just one bad attorney or a sign of deeper cracks in the system?
For you, Mr. Jones, I'm going to grant the motion to allow him to withdraw because he hasn't done a darn thing for you. Don't come back into this county until you're ready to practice like you should practice. Goodbye. Goodbye. I dare you to slam that door. Okay, I'm good. This Gaines, on this case, I think he stepped in or did whatever he did, but I don't think the PD was ever appointed. And I don't know. I mean, I want to get his case moving along because if
If the public defenders is appointed, we can get that discovery over to them. So it was such a transfer, everyone, get that over to them, public stairs tomorrow, that would be. Hard to document, please, for media, not one of all the files.
all in, okay. And
We could adjourn
the only
when
thing
we,
that I'm worried about is you're on this other case
I'm on the other.
because of a conflict with the PD.
Now the case takes
Correct.
a procedural turn, but don't mistake this for a slowdown. What the judge is doing here is actually critical, ensuring that Mr. Jones gets conflict-free representation. Here's the issue. If the public defender's office has already represented someone connected to this case or has another legal conflict, they can't ethically take on Mr. Jones. That's why you hear the judge carefully working through this conflict check process. And yes, it may sound bureaucratic, even a bit messy, but this is the system trying to correct itself in real time. The judge is essentially fast-tracking a solution to avoid further delay, even suggesting skipping steps if possible to get a qualified attorney in place quickly. It's also worth noting the tone shift here. After the earlier confrontation, the judge becomes more solution-focused, and even injecting humor into the courtroom to ease tension. That balance between authority and humanity, that's what keeps proceedings moving without losing control. Still, it raises a question. Should defendants have to rely on judges to fix breakdowns like this? Or should safeguards prevent it from happening in the first
Conflict with
place?
the PD,
Correct.
right? I'm just trying to make sure, is there going to be the same conflict? Because then we can try to skip that step. I mean, it sounds crazy, but skip that step to get somebody appointed that's going to represent him and talk to him about the case he's on.
Let me see if I can shepherd you.
Okay.
Cool, you go.
Oh, bring the baby back. See, that's upset. He took the only person I liked in the courtroom out. What, are you worried that she's talking too loud? Are you? Don't really, I'm serious. Don't worry about it. If she's got something to say, well, I'm gonna let her say it and we'll just all wait.
Nicolette. Oh, there you go, Mr. Jones. Okay.
Are they down in the back office? Because I think if they have a conflict, they have to figure out some way to do that and then get.
Typically comes.
Right, yeah, exactly, but I think what I need to do is appoint the PD first, then get the order withdrawal and appointing you, since I don't do the appointment, but. Okay, tell them, are they hearing it? They probably, I don't have them on.
No, they're not.
Can you let them know that on Mr. Jones' case that and tell them which one it is, and that Mr. Drukas has his other case. And we're not sure whether the PD has a conflict.
This moment is
Mr.
subtle,
Jones.
but incredibly important. The judge turns directly to Mr. Jones and apologizes. That doesn't happen often, and it speaks volumes. Why? Because it acknowledges that the system, despite its rules and structure, failed this defendant, at least up to this point. The judge makes it clear. This is not the way it's supposed to happen. That's not just reassurance, it's accountability. From here, the judge lays out a plan. Appoint the public defender, confirm the conflict, and if necessary, assign private counsel. It may sound convoluted, but it's actually a safeguard to ensure that whoever represents Mr. Jones can do so without ethical complications. And notice how the judge keeps checking for clarity, making sure Mr. Jones understands what's happening. That's crucial. Legal proceedings can be overwhelming, but especially for someone incarcerated. So here's something to think about. How many defendants truly understand what's happening in their own cases? And how much difference does it make when a judge takes the time to explain it like this?
Mr. Jones, I apologize to you. This is not the way it's supposed to happen, but I didn't do it, but we're going to try to make it as right as we can. All right. No, I just say, I just say that.
Based on Mr. Gaddy's look, I think we will likely have a conflict on this matter.
On this one.
Yes.
Okay, then here's, the approval chain to appoint counsel for him. Can you do that, Ms. Gaines? Can do that? Okay, so here's what I'm gonna do. This is gonna sound really weird. But I'm going to appoint the public defender. The public defender will then have a conflict. I then need an order from the MAC office.
I can,
And maybe I don't have to wait for the paperwork. Can you ask them that if the PD has a conflict, which it looks like they do, they'll get that. Will they be appointing Mr. Drukas? Because then I can proceed with this matter and we can go and we'll just follow up on the paperwork.
Mr. Juice, wanting to make sure that discovery gets to them tomorrow.
I'd ask for the week adjournment so I can review discovery if it does come to
See
me,
where-
and then we can come.
And I just can't appoint you myself.
Yeah.
And so I have to wait from a verification from them that that's what they're gonna do. To who? She doesn't have an answer yet. She should have an answer already. Type in this. Judge wants to know what's taking so long. Well, I think here's what I do. Since it's a PD case at this point, I'm just going to adjourn both cases out to the 9th. We'll just make sure to follow up today with all of the paperwork. Okay, on that. So I'll adjourn both cases, probable cause conference, April 9th, 2026, 9 a.m. Bond will continue in both cases. All right, Mr. Jones, you understand kind of what's going on?
Yeah.
At it. So one of two things will happen. It's likely that there's a conflict there, and so that you'll have Mr. Drukas for both of your cases. Okay. If not, worst case scenario, you'll have Mr. Drukas, you'll have the public defender on your case. But you got an attorney that's going to represent you. Okay. All right. We'll see you next.
The council just wanted to send the appearance direct, so we know who to send it to tomorrow.
Right. Okay. They'll make sure. All right. Thank you.
Thank you, Your Honor.
What we've just
That's
witnessed
it?
is more than just a courtroom exchange. It's a case study in what happens when legal responsibility breaks down and how the system responds when it does. Let's recap. Mr. Jones sat for over a month without meaningful legal representation. His attorney filed a motion that didn't accurately reflect reality, failed to communicate directly with his client, and neglected basic responsibilities like reviewing discovery. The judge stepped in, not just to correct the issue, but to call it out publicly and ensure it doesn't continue. We also saw the complexity of assigning new counsel, especially when conflicts arise. But through it all, the priority remained clear. Protect the defendant's right to fair representation and move the case forward properly. The bigger takeaway? The justice system isn't perfect, but moments like this show how accountability, when enforced, can restore balance. Now I want to hear from you. Do you think the judge handled this the right way? Should there be stricter consequences for attorneys in situations like this? And if you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.